Hello and welcome to our webinar today. This is Vin Banj from Taylor Wessing. Today's webinar is part of our regular webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have included looking at issues such as connected data, OBA and cookies, mobile apps and privacy, data transfers, and also the new and forthcoming EU data protection regulation. And this is just amongst some of the many subjects that we've covered so far. And recordings of those webinars are available if you missed them and still wish to engage with us on those particular topics. In fact, some 30 plus webinars that we provide amongst our virtual data protection learning bank. Today, we will be taking a further look at the topic of data security and breaches. Many new attendees are on the webinar today, and so welcome to you in particular. Also welcome to those who are joining us as part of our regular webinar program. This is part of our monthly webinar program. As you'll see from the slide deck, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering. And we do so from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and into Asia. And we also list more details about the firm on the slide deck for your reference. Today's webinar is brought to you by Taylor Wessing's International Data Protection and Security Practice. Our team advises on all aspects of data protection and information law, and we do so from our office footprint. And that's a global 22 partner-driven team, which is also complemented by our international network of data privacy law specialists to help provide you with a true global one-stop shop service. At Taylor Wessing, we have a dedicated microsite specifically for all things data protection, and that's our global data hub. From this site, you'll be able to access news which is updated weekly. If you register, you'll also have access to our regular and often monthly mail shots. You'll also be able to access the topical issues where we take a look at those issues that are raising concerns or challenges in the space of data protection and privacy. You'll be able to access webinars and also be aware of the different events that we are doing around the world and those events that we are attending or speaking at outside of Taylor Wessing. We also feature some of our international content, including our country pages, where we provide international coverage on those other areas of data privacy law. In terms of the presenters for today, I've already mentioned my name is Vin Banj. I head the data protection practice here at Taylor Wessing. Today, we also have a few members of the international data team presenting, and given the range of issues covered by this topic, I'm delighted to be joined by Paul Glass, who is a partner in our data breach investigations practice and very experienced in the area of data breach incidents and liability matters. I'm also joined by other specialist associates in this area, Jessie Prynne and Chris Wheatley. So what are we covering today? In a moment, I'm going to provide you with just a few minutes of an introduction around the area of data protection and data security requirements and the direction in which that's heading. And after I've done that, I'm then going to hand over to Jess Prynne, who's going to lead us through the TalkTalk incident. Paul Glass will then walk us through his thoughts on the next two areas that we have on the agenda, which is with the business benefits of preparing for a breach, and also the current breach landscapes and the threats and risks involved there. Then Chris is going to take over and look at some of the litigation risks in particular. And in the usual way, if you're used to our webinars, we will then have a session where we're going to look at some polling questions, where we invite you to click away as we introduce the polling questions and give us your views on those specific questions that we are looking at today. Our regular attendees will know that we always make an attempt to make very clear at this stage that your responses are anonymous and aggregated, so it allows all your fellow attendees to get a view from those attending the webinar today on those particular points. So please do feel free to click away when we get to the polling question stage, and we'll look at the answers which will come through very shortly after the polling closes. So I wanted just to take a couple of moments to recap on a few points in terms of the link between data security, breaches, cyber, and of course the fundamental topic of data protection. If we were to just take a step back, and I'm sure most of you are familiar with the EU Data Protection Directive, and in particular the directive going back to 1995, Directive 9546. Article 17 of that directive lays down a data security obligation. That data security obligation is reinforced in each local implementing law across Europe. So in the UK, we have the Data Protection Act 1998, which in Principle 7 contains the same data security requirement. And we've looked at this in detail before, so I'm not going to touch on this in any more detail today. And you'll all be familiar with that fundamental requirement for data controllers to take appropriate technical and organizational measures to safeguard data against certain risks, for example, accidental loss, damage, or destruction to data. And the key thing I want to point out here is that this is not a prescriptive approach to data security. This is a risk-based approach. Now, there's so much talk about the data protection regulation, which we think will hit the statute books, as it were, in the early part of 2016. And how will that deal with this same Article 17, Principle 7 requirement around data security? Well, it will maintain, we believe, the same risk-based approach, but it will also have a universal breach reporting requirement. So let me just take a few moments to just recap on some of these areas that we have already touched on before, but it's quite relevant just to explore those for a couple of moments before we look at today's very specific breach-related topic. Now, most of you will know that in January 2012, the European Commission unveiled its draft data protection regulation, which is intended to update and harmonize EU data protection law. Now, here we are almost 4 years later, and the draft is still being hotly debated, but it does look like it's nearing the end of that process. And we expect to see this finalized in very early 2016. There is a faint hope that it actually may even be finalized by the end of December, but the early weeks, and in fact the months of 2016 will perhaps be required to get that complete finalization process through. Over the last 12 months, we've seen that the European Parliament has approved its own proposals, and the European Council has also published provisional proposals on parts of this draft regulation that was released by the Commission back in January 2012. Now, the regulation has been described as the most lobbied legislation in EU history, and few issues have caused more consternation than the proposals around dealing with data security breaches. Under the current draft proposal of the regulation, there would be mandatory reporting of data security breaches. Organizations would have to inform the relevant data protection authority, the DPA, of a breach, and do so without undue delay, and where feasible, not later than 24 hours of becoming aware of it. In addition, they would then have to inform data subjects without undue delay, unless the relevant DPA was satisfied that the data was sufficiently protected from being accessed by an unauthorized user. In other words, or a more relevant example would be, it was protected by some form of encryption. Data processors would also be subject to the still more onerous requirement to inform data controllers and to inform them immediately of any data security breach. That's very relevant and a very different landscape, particularly for the supplier and vendor community to note. So let me just for a moment outline some of the key issues that this presents. Now, most obviously in the Commission's draft, there are no exceptions to the requirement to notify data security breaches to the data protection authorities, the DPAs. This means that every security breach, no matter how insignificant, would in theory have to be reported. Not only would this place a huge administrative burden on organizations, the European Commission does not appear to have thought about how the DPAs would process, let alone actually act on, all of this information being reported to it. Also, in order to comply with the timeframes, data controllers are likely to have to provide incomplete notifications to be supplemented at a later date, thereby adding to the administrative burden for all concerned. There is nothing in the Commission's draft which appears to stipulate how data protection authorities are supposed to deal with the notifications of security breaches that they receive. So despite the tight time constraints that are applied onto data controllers and data processors, there are no time limits within which the DPA needs to respond back. This is particularly important given the stipulation in Article 32 of the regulation that it is unnecessary to inform a data subject of a breach if the data controller can demonstrate to the authority that the data is encrypted or otherwise protected from access. So part of that process requires specific time protocols. The other part of the process has nothing prescriptive about it at all. Another issue is with the lack of guidance to the DPS and the time of response, and in particularly the possibility of facing some comeback on data security breaches from the DPA long after it's been dealt with by the data controller. So again, some practical challenges begin to emerge, as well as, of course, the increased administrative burden required to deal with this level of breach reporting. So in what direction do we think things are heading? It does seem likely, in my view, very likely, that there will be some degree of, want of a better expression, watering down of the data security breach reporting requirements. Now, with considerable pushback from the DPAs, as well as from businesses and member states and governments, the European Commission has said it will look again at this particular part of the process. So, if that's a view from the Commission, what about the European Parliament? Where did it stand on this part of the regulation? Well, after protracted negotiations, the European Parliament adopted its proposed changes to the Commission's draft regulation, and we saw from that the breach reporting provisions had indeed been somewhat watered down from that starting point from the Commission, from the Commission's draft. In particular, the revised Article 31 states that a data controller has to report a breach to a supervisory authority without undue delay, and the requirement to do so within 24 hours has been removed in the European Parliament's draft. The requirement on the data processor to inform the controller of a breach has been changed from immediately to without undue delay. So you can see that shift appearing as this moved from the Commission to the Parliament's draft. Information regarding the breach can also, if necessary, be provided to the regulator in phases. It is interesting that the corresponding recital to Article 31, particularly recital 67, had been amended so that the duty to report a breach to the supervisory authority within 24 hours has been changed to within 72 hours. The recitals only serve to provide guidance on the interpretation of the articles of the legislation. The 72-hour time limit is confusingly not set out in the article itself, so it still remains somewhat unclear as to how much force it will have being interpreted and applied in the way in which it appears within the Parliament's text. In terms of Article 32, from the Parliament's perspective, this deals with reporting data breaches to data subjects. There were no significant changes proposed by the Parliament other than a slight extension of the circumstances under which data breaches needs to be reported to include any adverse impact on the rights and legitimate interests of the data subject. And finally, what about the European Council's proposals, particularly in relation to data breaches? The Council proposals for changes to Article 31 and 32 go further than those made by the Parliament. Like the European Parliament, the Council suggests that data breaches be reported to the supervisory authority without undue delay, and where feasible, not later than 72 hours of becoming aware of it. The Council does, however, also include a qualification on the nature of the breaches which warrant reporting, saying that only a data breach likely to result in a high risk for the rights and freedoms of individuals, such as discrimination, identity theft or fraud, financial loss, or any breach of any pseudonymity around the data processing, or the damage to reputation, loss and confidentiality of the data protected. These are the areas that need to be reported. In addition, no notification to the supervisory authority is required unless a notification also of to the data subject is required. Now, the Council proposals do address the issue of what to do in the case of a minor or insignificant breaches, but still fail to place any obligations on DPAs in terms of the timing of their response. It has to be recognised, however, that this position for the Council is a more sensible and a more risk-based approach compared to the starting point from the Commission. My summary over the last few minutes is available on the Global Data Hub that I mentioned earlier, under the data security tabs and also under the tabs for the very specific content we produce on the data regulation. So please do refer to that, which is why we haven't created specific slides on this area. This is more of a recap of what we've already produced. So what's next? We still need to be patient for just a little bit longer to see how the text of the regulation will settle and to see whether the lobbying has paid off and whether the data security breach reporting requirements become more realistic. Personally, I don't think there's going to be any significant watering down, certainly not in any real sense, although the degree to which the text will shift away from the 2012 starting point is still really the million-dollar question. Whilst we have been in this period of wait and see for nearly 4 years with the regulation, in the meantime, of course, data breach incidents themselves have not taken a break. In fact, quite the opposite. The more recent high-profile example is that of the much-publicised data breach incident at TalkTalk. And to examine this and the lessons learned in a bit more detail, let me first hand over to Jessie.
Thank you. I'm going to be talking about what happened with the TalkTalk cyber attack that took place recently and the announcements that followed it. I'll then talk about the issues that these gave rise to, the impact of the cyber attack both on TalkTalk and more generally, and what you can learn from this incident. So moving to what happened. On the 21st of October, the cyber attack was discovered. Late on the 22nd of October, TalkTalk both notified the attack had happened and also announced it to the public. This was in a BBC interview that the chief executive, Dido Harding, did late on Thursday night. Many of us will probably have been aware of it early on Friday morning in the news reports then. When it was announced, TalkTalk did not know how many customers had been affected, but said it could potentially be all their customers, a total of 4 million people. They did not know what data had been compromised, whether it was personal details, bank records, credit card details, and they were not clear as to the extent to which the data was encrypted or not. On the 24th of October, TalkTalk were able to update the media that they expected the amount of financial information that had been accessed to be materially lower than initially believed. On the 26th of October, there were reports that a first arrest had been made in respect of the attack of a 15-year-old from County Antrim. Also on the 26th of October, the Culture, Media and Sport Committee announced that it was launching an inquiry into cybersecurity in direct response to what had happened at TalkTalk. On the 30th of October, TalkTalk gave updates as to the numbers affected, now saying that at most 1.2 million email addresses, names and phone numbers have been potentially compromised, 21,000 unique bank account numbers and sort codes, 28,000 obscured credit and debit card numbers and 15,000 customer dates of birth. By Friday the 6th of November, so 16 days after the attack had been discovered, TalkTalk was able to confirm, and these are the final figures that we have, that just under 157,000 customers' personal details had been accessed, 15,656 bank account numbers and sort codes, and the 28,000 obscured credit and debit card numbers, being a total of 1.2 million pieces of customer information. At the time of making its half-yearly results announcement, TalkTalk also confirmed that the one-off cost of the cyber attack was expected to be £30 to £35 million. So the issues arising from this train of events. The first quotation there comes from TalkTalk's website at the time of first announcing the attack. It says it was a difficult decision to notify all our customers of the risk before we could establish the real extent of any data loss. And this echoes what Dido Harding said when she went on the BBC News to announce that the cyber attack had occurred. The issue here is that TalkTalk was caught in the difficult position of wanting to inform its customers that the attack had occurred in order that they could be vigilant about their bank accounts, credit cards and such like. But at that time, they didn't have details as to the number of customers affected or the data taken, and the IT forensics were ongoing. They also, as mentioned, couldn't say the extent to which the data was encrypted, and this was a real issue for them. The second quotation is taken from a former government technology advisor who was commentating around the time of the TalkTalk cyber attack. He said that everything we have seen suggests that TalkTalk historically may have failed to take reasonable steps, and that the CEO appears completely out of touch with the risks that are widely described. This highlights that one of the other issues in relation to this attack, which is that it was the third attack to be suffered by TalkTalk within 12 months, previous ones having taken place in February and August of this year. And though lower profile than this cyber attack, nonetheless there being three in such quick succession did give the impression that TalkTalk didn't have the necessary measures in place to deal with such attacks. The final quotation is the announcement by the Culture, Media and Sport Committee that it was launching its inquiry into cybersecurity in light of the attack. So moving now to the impact of the cyber attack. Well, in terms of the impact upon TalkTalk, from the date of discovery of the attack, TalkTalk share price began falling, and by the 26th of October it had fallen 10% from before the cyber attack had been discovered, at least. By the time of its half-yearly results, shortly before, its share price had dropped further to about a 20% share price drop from compared to before the cyber attack had been discovered. It has now stabilised somewhat and improved, but it's still markedly down from where it was before the cyber attack occurred. As already mentioned, TalkTalk considers the cost will be £30 to £35 million for the cyber attack. It's not clear if that incorporates all its potential liability, but it seems likely that is the case. TalkTalk has also suffered significant reputational damage. As already mentioned, an inquiry has been launched, and interestingly, the EE CEO shortly after the attack said that they too had experienced a heightened number of attacks following the TalkTalk cyber attack. Perhaps one can hypothesize that these were hackers thinking that if TalkTalk systems were so easy to hack effectively, they could try other internet service providers. What also is worth highlighting here is that although in their half-yearly results, TalkTalk only had a small percentage change in the churn of customers, a small increase in the churn, nonetheless, it may well be the case that in future, cyber attacks increase the amount of churn of customers, and it remains to be seen the effect that this cyber attack has on TalkTalk's customer churn. So moving to what you can learn from the TalkTalk cyber attack, I think the most significant point here that the attack raises is the need to be pre-prepared for such potential cyber attacks. It's important to audit where your company is and implement measures accordingly. Compliance depends on the nature of your business, its circumstances, and the industry in which it operates. But what remains the case is that many breaches are the result of businesses failing to implement relatively basic security precautions and procedures, which can include encryption, updating software, retaining data for longer than necessary, vetting employees, and such like. Companies also need to be aware in advance of any attack what their legal and regulatory obligations are. having an understanding of their contractual and tortious liability, but also their regulatory obligations. In the case of TalkTalk, as well as notifying the ICO in respect of a cyber attack of this scale, they are also regulated by Ofcom and so had notification obligations to them. Having an awareness of this in advance of an attack is extremely important and helpful. In terms of practical measures, this refers principally to employee handbooks, internal handbooks of what to do in the case of an attack. It's worth mentioning here, and perhaps a story that's oft repeated, but that for BP, when they had the Deepwater crisis, their crisis handbook was about 750 pages long and therefore had been read by very few people. What you need are short, up-to-date handbooks that are regularly reviewed and revised as required. One of the points that perhaps would be a learning point for TalkTalk is that in respect of encryption, the level of encryption of their data, both that was being processed, that was going externally, as well as their internal data, they should have been aware of the level of encryption of that. And had they been so, it would have helped markedly, perhaps, when they first made their announcements as to the breach. So having policy handbooks in place is important. And finally, reputation. It's important to have a PR agency with whom you are in contact, who are aware of how to handle communications around a cyber attack, but also are aware of your company, the nature of your business, and what attacks you may be liable to. Having all these elements in place will help in the event that you do suffer the unfortunate consequences of an attack. That's it from me. I'm now going to hand over to Paul to talk about business benefits of preparing for a breach.
Thank you, Jessie. We've spoken in previous webinars and written on the Global Data Hub itself about sort of breach preparedness and what can be done to improve your ability to respond to a breach when it happens. Jessie's just touched on some of those issues again now, but really it's about getting yourself in the best position possible to be able to deal with what is unquestionably, and I think TalkTalk demonstrated this very well, a firefighting scenario. And as much as you can put yourself in the position to know where you stand on issues in advance of actually having to fight those fires, it makes the breach response scenario, the first 48, 72, 96 hours, much easier to deal with. I'm going to talk on a slightly different issue now, which is some of the other business benefits that you can see from preparing for a breach properly. Now, the statistics on how many businesses suffer breaches are clear. And to quote the example from the Department for Business Innovation and Skills from June 2015, their review found that 90% of large organisations reported they'd suffered an information security breach, and 74% of SMEs reporting the same. If you couple this with the average length of time that it takes a business to discover a successful attack, which typically varies from between 200 and 280 days, the chances are that a good number of those organisations which reported that they haven't yet suffered a breach, in fact have, but don't know it yet. Now, clearly all information within a business is not worth protecting. Vin's already mentioned the requirements under Article 17 of the Data Protection Directive and Principle 7, and that sort of covers the bare minimum for data controllers. As a matter of good practice, companies should also be taking steps to identify sensitive personal data and ensure that appropriate steps are taken to protect that data, and should also take steps to identify effectively the information which they wouldn't want in the public domain or in the hands of a competitor. And that's whether or not it constitutes personal data, confidential commercial information, intellectual property, and take steps to protect that information. Now, we've seen a real change, I think, in the last 12 to 24 months in board engagement and responsibility on cybersecurity. But there's still a long way to go, particularly on the importance of preparing properly for a breach. If companies have a breach response plan, and many still don't, often it's written once, then not tested, and sits at the back of a filing cabinet. we still hear all too often about companies that aren't prepared to allocate budget to the exercise of properly preparing for a breach, testing the breach response plan, and then reviewing and updating it on a regular basis. Now, the level of planning and testing which is appropriate will vary from business to business and depending on the type of data held and the value of that data to third parties who may want to access it. Preparing properly for a breach is an exercise that can be carried out in varying degrees of detail and depth, but a full review and preparation exercise will involve a number of processes and teams across the business and should, in reality, be factored into the business's overall risk management strategy and business continuity plans. In its most detailed form, the process of preparing properly for a breach involves a number of work streams which may not be immediately obvious simply from the point of view of breach readiness and can lead to a number of ancillary benefits. First, it's important that a business knows what data it holds, to categorize or classify that data, and then critically to identify where that data resides, how it can be accessed, and how and where it flows within the business. Now, this isn't a theoretical exercise. It's important to get an understanding of where the data actually resides and moves, not where you think it resides and moves according to your IT policies. And the unfortunate reality is that most businesses' IT and data policies aren't reviewed often enough, are often out of date, and don't reflect the day-to-day practice of employees, and more worryingly, in terms of getting the right tone from the top, the day-to-day practice of executives. Now, there's no sort of right answer, definitive answer as to what an IT or data policy should contain, but the reality is they are sort of more often observed in the breach, perhaps, particularly if policies are too restrictive or too loose. Now, the process of reviewing where data sits within the business and how it moves around and understanding this in advance means that you'll be in a much better position if a breach has occurred to work out what data is likely to have been compromised and to focus efforts on identifying the true scope of the breach in the right areas. At its simplest, investigating a breach involves working out what parts of the network attackers have accessed and what data could therefore have been compromised by that access. As recent events show, getting the scope of data access wrong can make a breach appear much worse than it actually was. Reviewing where data actually resides and moves will also mean that you can potentially identify inefficiencies or business process improvements which are entirely separate from breach preparedness, often with significant savings to the business. It may also highlight flaws in business continuity plans which aren't related to data breach, or highlight inadvertent or unidentified breaches of data protection legislation where, for example, data is being transferred outside of the EU without appropriate measures in place. Second, you can often identify risks which have arisen due to workarounds by staff, or simply a risk which has not been considered before, which is occurring in practice. Appropriate steps can then be taken to revise policies to deal with the issue, or, if appropriate, put technical measures in place to limit or prevent the behaviour in question. And that process can actually enable you to reduce the risk of a breach even occurring. Third, a full breach preparedness review can identify regulatory risk and defects in information security policies which have grown up over time. Now, in practice, I think we all know, a business's IT estate is always changing, new software is incorporated or added, new apps are developed, new ways in which a business can interact with its clients and customers. And reviews relating to these changes are often conducted sort of in isolation without looking at the overall IT estate. Over time, risks build up which aren't identified, and the process of undertaking a full breach preparedness review can help to identify those risks, and the business can then take a more informed decision as to how to deal with them. Fourthly, the process of full preparation or full breach readiness exercise can actually allow for other benefits, such as the identification of what's now being called dark data. And this is information which is collected, processed and stored during regular business activities, but which isn't used. It just sits within the business. Nobody really does anything with it. And consideration can then be given to what that dark data actually involves, and in fact whether the business can monetize this in some way, either directly or using it to improve systems and processes or create efficiencies in similar ways to what I've just discussed. Our view is that data security is in reality a form of business risk, which manifests in this digital connected world that we now live in. But businesses review and assess their risks on a regular basis as a part of business as usual. But in many businesses, data security risk doesn't yet appear to have crossed over into the realm of business risk. It should be assessed and reported onto the board on a regular basis, but isn't. And breach preparedness shouldn't simply be seen as a negative, a cost, or something that the business should do to put itself in a position to best deal with a breach. It can also be a positive, enabling efficiency and cost savings, and potentially also identify possibilities for the monetization of data which the business hasn't identified before. I'm now going to move on to talk briefly about the current data breach landscape and threats and risks that we're now seeing. And this comes from our own experiences in assisting clients in responding to breaches, and also from what we hear from third-party service providers also working in the sector. As Jesse's already alluded to, the breach that has really brought data security to the front of every board's mind in the UK is TalkTalk. It was the first major breach in the UK that's consistently made front-page news for several days, and Jesse's already talked about some of the issues that have arisen, so I'm not going to cover those in any more detail now. What we are seeing is that boards have really taken notice as a result of the media coverage in relation to TalkTalk. And we're seeing a number of queries from relatively young startup businesses who are data rich up to full listed companies, FTSE 100 businesses, who are now saying, are we in a position to deal with this? And are concerned that they're not. And what we're doing as a result of that is actually starting to expand the sort of breach readiness products that we offer to assist clients in preparing for breaches, and looking at sector-specific scenarios for clients, looking at the risks that entail in their sector. So a hotel's business, what are the risks that they'll see? How is that different from a retailer? And assisting clients in preparing for breaches, both on that basis and also fully bespoke to the individual business in question, taking account their existing policies and sort of IT data estates. Now, one of the things that came out of the TalkTalk breach was initial reports were that I think it was Russian cyber jihadists that we were originally blamed. Now, one might speculate as to why TalkTalk would be targeted by Russian cyber jihadists, but as Jesse said earlier, it turned out to be teenagers in London and Northern Ireland. We do hear of an increase in state-sponsored and cyber terrorist-sponsored attacks, and these sources of attacks tend to get a lot of media coverage, to some extent because of the political issues that they relate to. But it's still the case that such attacks form a very small proportion of the overall number of attacks. And unless your business operates in certain sectors such as defence or military, government, critical infrastructure, or the financial sector, you're unlikely to be the victim of state-sponsored or cyber terrorist attacks. Sony is the obvious exception there. Many attacks are still opportunists looking to cause trouble, or cyber vandals, or teenagers leveraging their skills and capability, but perhaps not realising the damage that they're actually causing until they cause it. They have time, inclination, and often reasonable skills, but they're often not looking to immediately monetize data they access. It's more about sort of cyber vandalism than actual financial gain. The greater risk for many institutions which hold substantial amounts of customer data, commercially valuable confidential information or IP, or simple financial information about the business, is cyber criminals who are looking to access or steal data for financial gain. The obvious targets are personal data, particularly where it will enable criminals to build complete identities or credit or bank card information that will enable financial fraud. For more sophisticated criminals, confidential information that may enable, for example, insider dealing or intellectual property stolen to order is also targeted. And many of the methods for accessing this kind of data aren't new. They've often been updated more recently, taking advantage of vulnerabilities or becoming more sophisticated, but still using the same underlying premise. Well-crafted spear phishing emails, even though it's something you hear about all the time, are still remarkably successful, particularly when they're combined with good social engineering. And as an example of this, something that we've seen from an actual attack, an attacker may identify that a particular company provides services to you, and may either compromise that service provider's systems because they're less secure than yours, or create a spoofed email address and send, for example, an email with an invoice attachment, and the attachment is seeded with malware of some sort. A good attacker will identify, using sources such as LinkedIn, who works in your accounts department, will identify how your email domain structure works, and therefore how they can spoof an email which looks as though, send emails to the right people. A good attacker will only send an email to a few people in, for example, the accounts department, rather than the older scattergun approach of targeting as many email addresses as possible. This means that the IT department isn't going to immediately have 20 people saying, we've had this slightly suspicious-looking email, what's going on? And that the sort of spam mass mailing of lots of people actually makes often easier to detect spear phishing attacks. An email like this will usually be sent late in the day when the recipient is slightly tired and might be less likely to actually spot that it is a spearfish. And in this example, sending an invoice seeded with malware, it could be sent, for example, in the first 10 days roughly of the month, when an invoice in respect of services for the previous month may be expected. Now, studies have shown that even poorly crafted spear phishing emails are still effective. Well-crafted ones even more so, with over 50% being opened within 5 minutes of receipt. Education and training are still key to minimising the risks of falling victim to a good spear phishing attack, along with tools such as Add into Outlook that, for example, place a big red button on the toolbar that people can click to automatically flag a suspicious email to IT for analysis. This makes it easy to report suspicious emails, but also having that big red button there all the time reminds people of the risk, and that can actually be very valuable. Moving sort of quickly on to a couple of other areas, we are seeing an increase in third-party derived attacks, and this sort of fits in with what I've just given as an example, which is where your systems may not be vulnerable. You may be quite secure. Are your suppliers secure? Is a way into your systems for somebody to actually compromise a third party who has, as a necessity, some form of access to your systems, and the attacker can then get in via the third party, access your systems that way. And regulators now are taking more of a proactive approach here. Instead of simply requiring or recommending obligations and warranties in contracts with third parties and relating to information security, regulators, particularly in the US, and we expect the same here, are now actually starting to take the approach that good practice is to go and kick the tires, so to speak, to actually go on site, see the processes, the security processes that your third parties have in practice, and testing them on a regular basis. Just touching briefly, the insider threat is still key. Nothing changes there. The proportion of insider-based threats goes up and down slightly, but not very much over time. And that is still about training and having good policies in practice. The reality is, do 100 people really need admin-level access to your network, or is it only 10 people? Having those policies in place and getting them right goes a long way towards limiting the opportunity for third parties to gain access, no matter what the external threat landscape looks like. I'm now going to hand over to Chris, who's going to talk about litigation risk arising from breaches.
Great, thanks, Paul. So as we all have mentioned today, I'm going to be going through some of the key litigation risks arising from data breaches. I'll also be looking at the relevant defences that may be used in those circumstances, and then considering the practical and commercial safeguards that can be put in place to try and manage those risks. I think before we get into a detailed analysis of those points, it's worth making the general observation that this is an area where courts, both on a national and European level, appear increasingly willing to find liability in the cases of data breaches, and will, where possible, try and protect the individual data subjects whose interests may have been damaged. And probably the best place to start in terms of liability under English law for data breaches would be the rights of data subjects under the Data Protection Act. And probably the main one of these worth considering at this stage are the rights of a data subject or of an individual to claim compensation from a data controller for damage or distress caused as a result of a contravention of any of the provisions of the Data Protection Act. Now, interestingly on this point, contrary to what's actually said under the terms of the Act, following the decision in Vidal, Hall and Google, an individual now claiming for damages for distress now no longer needs to also prove that they have suffered an ascertainable financial loss. So whilst this may not be significant in terms of the level of damages for each individual claimant, when we put this in the context of a much larger data breach involving the loss or theft of a high volume of personal client or customer data, and then the availability of multiple claims, group or class type actions, when this is all put together, the cumulative liability can present a real concern for the businesses involved. And this is where we get this expression almost of the death by 1,000 cuts type scenario. And then moving on from just the claims for compensation, under the Data Protection Act, individuals can also apply to the court under certain circumstances to either prevent the processing of their data under Section 10, or for the rectification, blocking, and erasure or destruction of their personal data under Section 14. And here the relationship between these two isn't actually that clear. Under Section 10, and a notice has to be provided by the individual concerned, and then they have to establish that they would be likely to suffer substantial damage, and that this damage would be unwarranted. When we compare this position to that under Section 14, which to a large extent provides similar type remedies to what would be sought under Section 10, there aren't these same hurdles to get over. The individual merely has to prove that they have suffered damage to the extent that would satisfy any claim for compensation under the Act, and that the contravention is itself ongoing and is likely to continue. Again, when we look at the Vidal Hall decision, it now appears certainly arguable that these type of Section 14 claims for rectification, erasure, and destruction could be brought where the individual concerned has suffered distress alone and no additional financial loss. This also potentially opens up scope for these type of claims being brought. I don't think if we now move outside of the Data Protection Act, I think businesses should be aware of potential liability under the doctrine of misuse of private information. And under this doctrine, this is a non-statutory, this is a tortious cause of action available to individuals. So an individual who suffers damage or distress as a result of a misuse of this private information could claim for a number of remedies. So this could be damages, it could be injunctive relief, or in severe cases, this could be for the erasure or destruction of the private information. And again, this is another example where on a national level, courts are showing an increasing approach to award higher levels of damages, as was seen in the Gulati decision. So where these previously used to be quite modest, the courts are increasingly trying to award this higher level. And now I think it's best to move on to the defences, and I think the key point to make here is that these are fairly limited. And in relation to, say, the Data Protection Act, when we look at Section 13 and claims for compensation, it is a defence if the data controller can establish that they have taken such care as in all the circumstances was reasonably required. And I think the best way to look at this is that this is a practical as much as a legal defence. This is about putting in the appropriate systems and controls and protections, making sure staff are trained, access is restricted to what is necessary, and information is only used for the purposes, of which you've acquired it in the first place. If we then move outside of the Data Protection Act and we look at the defences that may be available for the misuse of private information, these again are very limited, and essentially the defendant would have to establish either that this use was in the public interest, that the information itself was already in the public domain, or that the information concerned or damaged was itself trivial. These are very high thresholds to get over, and in any event their availability would be quite uncertain. So in this context, I think it's then important to really consider the key practical and commercial safeguards that can be put in place to help manage these risks. Now, obviously, from an internal business point of view, that would be having the appropriate controls in place, having the training, and, for instance, where data is stored on portable electronic storage devices, having the ability to remotely wipe that information, as this may help reduce the quantum of liability that you suffer in the event of a breach, obviously depending on the circumstance of the case. Then when we look to contracts in relation to or rather business contracts between, say, outsourced service providers or subcontractors or any other third parties for whom you do business with, which involve the transfer of personal data in relation to which you act as a controller, it's important to ensure that these have the appropriate protections in place. This is because when acting as a data controller, even if the processing of this data is outsourced to a particular organization, the data controller will still remain liable for the breach. So at the absolute minimum, you should try and ensure that these contracts contain an undertaking from the relevant provider to comply with the data protection regimes not only in this jurisdiction, but in each jurisdiction in which they are established, in which the data is transferred or processed. And that's both in Europe and internationally. There should also be obligations to notify you in the event of firstly any potential and then actual breach. This helps you practically respond and help reduce the damage of any data breach, whilst also enabling you to comply with any notification obligations that as a business you may have towards a regulator or towards your customers or clients. Sort of in tandem with that, we would also strongly recommend the incorporation of audit rights. And these are essentially obligations on your contractual counterparties to provide you with information surrounding the breaches and investigations. As particularly from a regulatory context, you will often need this information to report to your investigators, and this will enable you to respond and make the type of media statements that you may be required to make. Where possible, it would be useful also to try and incorporate undertakings to fully cooperate with you and the regulators in any investigation into the breach and also in terms of any responses. And I think here we've also touched on the idea of outsourcing service provision that involve the transfer of data. And I think here we have to be particularly alive to the issue that there may be further subcontracting of this type of services involving personal data that may happen further down the line. And therefore, it's quite important in these type of arrangements to ensure that you have the appropriate restrictions or limitations on these types of further outsourcing arrangements. This could either be a blanket limitation, or this could be a limitations in terms of only transferring that data with your consent and subject to the procurement of the obligations we've previously gone through. And I think the final point here is also to make sure, as far as possible, that you build in the appropriate indemnities into your commercial contracts to make sure that in the extent that you do suffer a loss as a result of a breach of an outsourced data processor, that you are able to claim from that data processor. It would also be useful if you're aware that this is a chain of contracts, especially in maybe a business-to-business sales context, that these indemnities are appropriately back-to-back right the way down the chain. I think finally, I'm just going to finish in considering not just the contracts you'll have with your service providers, but also with those of your customers. And this is really in consideration of once a breach has occurred, looking at the rights of termination that customers may have in relation to your contracts. Now, often this will depend on the terms of the agreement, and you may have to take a position in this and decide whether or how you would seek to control those particular rights of termination and how that should be managed in the event of a breach.
Okay. Thank you very much for that, Chris. Now, I'm aware that we're running sort of slightly late on time, but we'll move quickly on to the polling questions. These should now be on screen for you, and you'll have about 2 minutes to answer. I'll just read through the questions as well. Just to remind you of what Vin said at the start, the answers are completely anonymous, and this gives you the opportunity to sort of gauge what your peers are doing in relation to these issues. So the first question is, when did you last update your data breach response plan? And A is in the last 6 months, B in the last 12 months, C, it's never been updated, or D, we don't have a data breach response plan. Question 2 is, when did you last run a data breach response exercise to test your plan? A, in the last 6 months, B, in the last 12 months, C, in the last 24 months, or D, we've never run one. Question 3 is, do you have difficulty in obtaining what you think is sufficient budget for putting in place a detailed, tested data breach response plan? And A is a lot of difficulty in obtaining sufficient budget, B, some difficulty, or C, no difficulty. And the fourth question is, if you have undertaken a detailed breach preparation review, did you look for and or find other benefits to the business as well? So A is didn't look for any other benefits, B looked for benefits but didn't find or identify any, C is that you looked for and found minor benefits, and D is you looked for and found major benefits. Just to give you a little bit longer to answer those questions, I was going to remind you briefly of what I mentioned while speaking earlier, that we are in the process of working with a number of clients following the TalkTalk breach to actually sort of expand the breach readiness offering that we have for those clients. And this can be on a number of levels. It can be a relatively high-level review, going all the way down to actually engaging with the client, looking at their existing policies, looking at their IT estate, and actually running sort of exercises over a day or 2 days involving members of the board, the Chief Information Security Officer, etc., and having a sort of detailed review with clients of that whole readiness position that they're in, to enable them to be in a better position in advance to actually deal with the breach.
Thank you, Paul. And I think just whilst we're still waiting for the responses to come through, we do have some questions. I mean, the last few minutes, let's just try and tackle some of those questions. There's one question here which I think is perhaps for you, Jesse, and that's, what could TalkTalk have done better?
I think the tricky point probably for TalkTalk on this is what they could have done better before the attack occurred. So once it had occurred, they were, as I mentioned it earlier, they were in a difficult position because they had to notify their customers in the context where they didn't know how many could have been affected and what data could have been compromised. But by that point, in effect, some of what they could have done better was too late. I do think this point on encryption is quite significant, because that is something that they could have had a better understanding of in advance of the breach. If they'd known what both their internal and external levels of encryption of data that was being transferred was, they could have given a more confident response at the time of announcing the breach. And I think that would have certainly assisted them in seeming more in control of the attack. Just briefly, I'd also mention that some of the commentators around this breach, whilst it remains unclear as to the exact nature of the breach, some commentators have suggested that rumours of the type of breach it was, whether it was a distributed denial of service accompanied by an SQL injection, essentially a way in which hackers can get access to information behind a database. These breaches are considered relatively straightforward, and commentators did say they were surprised that a company of TalkTalk's nature may have been subject to such a breach. So also addressing technical measures, if that is indeed the case, would have been important.
Thank you, Jesse. Just a couple more questions which I'll try and answer very quickly in the minimal time that's left. One question here, which is, can you say something about and add anything about the fines? It seems that the European Parliament said 5% or 100 million euros, whereas the Commission had said 2%. It's still not clear where this will settle. In some ways, my advice to many clients that we're talking to at the moment is, whichever the figure, whether it's ultimately 2% or 5%, this is going to be a huge shift from what we have under current regime. So we're talking moving from fines which are in the hundreds of thousands of either pounds or euros to millions of pounds or euros. If there is indeed no 100 million euro cap, then certainly for most Fortune 500 or FTSE equivalent companies, we're talking about the potential for fines into hundreds of millions of pounds. So certainly I guess larger companies will be much more aware and waiting for and perhaps more appreciative of any cap that may be applicable, so perhaps hoping for that €100 million cap. I think the potential here for such large fines will certainly, or ought to drive accountability. It ought to drive a greater degree of governance around data privacy and data breaches and readiness in particular, because the sheer scale of liability that can arise, well, we've all seen that. That's been part of our core discussion in the webinar today. But in addition to that, having the potential for a fine that is in the millions or hundreds of millions of pounds will certainly add to that overall liability scenario if you have the unfortunate scenario of facing a data breach of any significance. Paul, do we have some of the responses through?
We've got a response to the first question. I think we're having a slight technical issue with getting the results through. The first question was, when did you last update your data breach response plan? And somewhat hearteningly, the results that I've got are that 42% of you last updated the breach response plan in the last 6 months, 30% within the last 12 months, slightly worryingly 18% saying it's never been updated, and 6% saying that we don't have a data breach response plan. I'm just seeing if we can get we've now got the answers to the remaining questions. Question 2, which was, when did you last run a data breach response exercise to test your plan? 30% said in the last 6 months, 9% said in the last 12 months, another 9% said in the last 24 months, and finally, D, slightly worryingly, we have 48% saying that they have never run an exercise to test their data breach response plan. And I think at the moment those are unfortunately the only answers that we've been able to get. Just a slight technical issue on those.
And what we will do is, as when we resolve that technical issue around the polling results, we will try and make sure we distribute those certainly to the attendees, and certainly look out for our tweets and updates, and we'll make sure we cover those statistics for you as well. Conscious that we are running up against time now, I just finally wanted to mention that our next webinar will be on the 15th of December, when we take a look back at some of the key developments of 2015 in this area of data privacy and data security. And also we're going to have a look at the data protection tea leaves, as it were, see what 2016 holds for us. So we hope you can join us then on the 15th of December for our final webinar of 2015. But for the moment, and from the team here today, goodbye.